First, if you are referring to sources of law, we are basically referring what are the ways we can source for our law. What are the ways we can find our law? What are the things that give rise to what the court can rely upon to rule on a particular matter before it? That is what sources of law entails. So through this topic, you'll be able to understand what forms the first end to ringo of every law. What is the fountainhead of all the laws that are applicable in your jurisdiction? That is what this topic is all about. Come to think of it, as a law student, you have come to study law and you don't know sources of law. You'll never come across it in your entire journey. So it's now you are going to know sources of law. When we say this, when we say that, when we say textbook, when we say Nigerian legislation, when we say legislation, when we say constitution, do you actually understood it? That is what we are going to do. Now, sources of law. I'm using common law as a point of contact. So whatever we are treating here, regardless of whatever country you are from, this thing still applies to you. Don't worry, at the end, I'm going to tell you how we are going to answer any problem coming from here. I'm going to tell you how the lecturer is going to ask you questions, what you expected to know regarding this thing. Just stay tuned. If you are somebody dealing with legal method, legal system, this topic, sources of law, is one of the topics we are going to be confronted with, especially in second semester. So you are going to understand the sources of law. If you are in Nigeria watching this video, you will be dealing with sources of Nigerian law. If you are a Ghana watching this video, you will be dealing with sources of Ghanaian law. If you are in Zimbabwe, Zambia, Kenya watching this video, the same thing applies, but the only difference is just some certain element that has to do with your own country. So I welcome you to this video. Because of the importance of this topic, today we have decided to talk about what? Sources of law. And I encourage you to pay attention because we are going to treat everything you need. And trust me, even before your lecturer commences lecture, you will be at grasp with this very topic. It's very important because you need it in your understanding of the overall meaning of law and also to proceed there as a legal method or a legal system law student. So we won't waste much time today. We shall be delving into the topic because time is money on my own side. Now, let us consider sources of law. When we talk about sources of law, what actually do we mean before we even consider all the things that are written in the board? And as you know, we that are very intelligent, we often have good handwriting. You understand now? So as you can see, this is a beautiful handwriting written by the King's Advocate himself. Trust me, I have the most perfect handwriting in the world. You understand now? So I believe you can actually understand everything that is written there. If you cannot, don't worry, tell me in the comment section. When we say sources of law, what do we actually mean? When we are talking about sources of law, what do we actually mean? First, if you are referring to sources of law, we are basically referring what are the ways we can source for our law? What are the ways we can find our law? What are the things that give rise to what the court can rely upon to rule on a particular matter before it? That is what sources of law entails. So through this topic, you'll be able to understand what forms the first end to ringo of every law. What is the fountainhead of all the laws that are applicable in your jurisdiction? That is what this topic is all about. Come to think of it, as a law student, you have come to study law and you don't know sources of law. That's why I said it's a very critical, important topic if you are dealing with legal method and legal system. Because that is where you are going to, after this topic, you will not come across anything like this in your entire journey. You will never come across it in your entire journey. So it's now you are going to know sources of law. When we say this, when we say that, when we say textbook, when we say Nigerian legislation, when we say legislation, when we say constitution, do you actually understood it? That is what we are going to do. Now, sources of law. I'm using common law as a point of contact. So whatever we are treating here, regardless of whatever country you are from, this thing still applies to you. Now, so don't be carried away by the fact that you are seeing Nigerian legislation here. We are using common law as a whole, but Nigeria is a point of reference. So whenever you see Nigeria or you have me mention Nigeria, just replace it with your own country. Replace it with Ghana. Replace it with Sierra Leone. Replace it with any country you are watching from. It's still the same thing. As far as provided you are under common law, provided that it was Britain or America that colonized you. If not, just leave this video. If you are from French colony, just leave the video. Now, we talk about the four sources of law. Receive English law. Receive English law is the first beginning of our legal jurisprudence as far as you are in common law. Before 1800 to 1900, there is something known as what? rules of common law being applied in all the colonies of the Britain. Are we together? Are we together? So that is what this received English law is talking about. They are talking about those English laws that has been in place before we got our own independence as a country. Now, when we got our independence, those English laws were not jettisoned totally. They were received. They were adopted. That's what we mean. They formed a part of our legislation, meaning that anything that has been in England before, or anything that they called, remember before we got our independence, there has been court system. Because of that, because of those court system, whatever the English have ruled based in common law, based in state, all of them, they are still applicable as received English law. So when we say received, we mean adopted or doctrinated English laws. Are we together? Received English law is in three parts. We have the common law, we have then the principles of equity, we then have the statutes of general application, applicable in England from 1st January 1900. What do we mean? Under received English law, as we describe it, it is a law that is borrowed from what? English law. Those laws that have been applicable before we got our respective independence as a nation. That is what this one is all about. Now, under this one, we have it three, which I have mentioned. Common law. We all know common law. If you don't know common law, if you go to this channel, there are videos that I have made that talks about everything about common law. Now, we also have what? Statutory. We also have what? Principles of equity. When you come up in your 400 level, you will be dealing with equity as a course. Now, equity is another principle of its own that forms part of our corpus juris. Principles of equity, we all know the origin. That's why I encourage you to go and watch my video on common law and equity, because that is where we discuss it. But just know it that part of our law is received English law. Under received English law, we have common law, we have principles of equity, and then statute of general application. That means any statutes, all those laws written down that have been applicable in England from 1900. That is from 1900, not anything below 1900, from 1900. They are all applicable in Nigeria. Till that time we got our independence. That is what we mean by received English law. Are we together? Please, if I'm doing you well, subscribe. Now let us proceed. I believe you have understood that part. Now let us proceed to number 2, which is Nigerian legislation. By the way, before we go, I want to encourage you that every single Saturday and Wednesday we used to post academic tutorial video here. And if you don't want to miss out, you can subscribe so that you stay updated on all our videos as it happens. Who knows, that one may make you get A. Trust me now. Now we talk about Nigerian legislation. This one refers to all those laws that has been written down. That is how I want you to understand it. I don't want anything to be hard. Whenever you talk about legislation, it means what are those ones that have been written down. Let me find one of my laws here. This thing I'm carrying here, this one is 1999 Constitution. Let me know where it can be placed here. Oh, place now. Cannot be placed here. So, but this one is one of our laws, 1999 Constitution. Now, this one is what? Freedom of Information Act. Anybody that offer press and media should know this thing, right? So, place it here. Now, this thing is a legislation. So, if you want to classify this thing, you classify it under number 2. And what do we even mean? When we are talking about legislation, we just simply means any law that has been legislated by the House of Assembly for the state and then National Assembly for the Federation. Under Section 4 of the 1999 Constitution, it grants power to the federal government and state government respectively to legislate on anything that we will call law. When you talk about Nigerian legislation, there is a lot of things involved there. We have the Constitution. Constitution is the chief legislation. As a matter of fact, any other law that is inconsistent with the Constitution is null and void. So if this law is valid because it draws its precedence from what? Section 39 of the Constitution. In other words, if any provision here is contrary to the Constitution of Section 9, it will become null and void. There are so many laws.
Law confusing? Let's make it simple. At lawmadesimplelegal.com, we break down the hardest legal concepts into easy-to-understand lessons. Whether you're a student, lawyer, or just curious, you'll find clear explanations and real case analyses across fields like criminal law, contract, tort, and constitutional law. This is where law becomes easy and practical. This platform was created by Kingsley Omenyi, simplifying the law for Nigerians and beyond. Visit lawmadesimpleLegal.com or simply scan us on Google to discover how easy law can be.
This one is the only act I can bring closely with me now, but there are many acts. We have rules of professional conduct, we have same-sex marriage act, we have a lot of maritime act, arbitration act, a lot of act. But what you ought to know is that all of them are classified as Nigerian legislation. So anything that have been legislated upon, be it National Assembly or House of Assembly, all of them are basically regarded as what? Nigerian legislation, and they forms part of our law. That is basically this topic will come. No worry, at the end I'm going to tell you how we are going to answer any problem coming from here. I'm going to tell you how the lecturer is going to ask you questions, what you expected to know regarding this thing. Just stay tuned. And by the way, have you liked the video? If you have not liked the video, please like. That is the way you support. Remember, I'm giving up my time. I'm supposed to be doing another thing, but I'm here lecturing you. The only way you pay me back is by reacting. Just like the video. Do not take anything away from you. Now we'll come to case law. This one is the simplest part of it. When we talk about case law, we are referring to only judgment that has been given by any court. And on our next video, I will be taking you people possibly on judicial precedents and hierarchy of courts, because that is the better way to understand case laws. Remember, this is the first video for our second semester, and by the end of this semester, we shall cover everything in second semester. It's all about you being intentional by subscribing and coming and checking video here every Saturday and Friday. It's very, very important. Check it Friday, Saturday, or something like that. Now, when we talk about case law, there are judges made decision. Case laws has anything to do with what? Judicial precedents. The major takeaway from case law is that whenever a court decides a matter, they don't just throw the decision away. Let us assume there is a dispute between you and I, and the courts have ruled on the matter that I'm the person that is the owner of this land based on so reason. If any other matter comes between Okeke and Okonkwo, and it has everything to do with what? Who owns the land, and they share similar facts. Fact means what happened in Okeke case is what is obtainable in my own. The court will just rely on the decision they give between two of us to apply it in Okeke and Okonkwo. Are we together? It simply means that the judges don't throw away their judgment. Whenever a matter comes up, they go and look whether that matter has been decided before in such a similar way. If it applies, they will apply the judgment. So the only thing you have to do as a lawyer is to come by court and say, my lord, in the case of Okeke and Okonkwo, this court ruled that this thing is this based on this reason. My lord, look at this case. So this my client is similar, his case is similar to this one. Why don't you rule in my own favor too? My lord will be like, well, you are correct. So we are going to apply this decision here, and it becomes law. That is why we say case laws. What we do is that as a lawyer, you go and cite case laws to support your case. That's why lawyers read every day, because if a matter comes up, a lawyer will go to library and read and study any case that he can use to back up his argument. That's why when you go to exam, they will tell you, using all the relevant authority, you begin to write, you begin to think around any authority you can use to support yourself. This is based on this idea as a source of law. Whatever you cite here becomes binding. So it's a very strong authority. Now we have customary law. Customary law is the laws of our forefathers. Every person here watching me have their own customs. So those your customs are still relevant laws. But the pictures, the overall characteristics or the problem of customary law is that it is not written down. So it is a question of fact, and you need to prove it. Unlike law, you don't cite section 1.1 and started proving it to. You don't cite section 1.1 and start to prove it to my lord. No, my lord is deemed to know the law. But if you cite customary law, if you say that this is how your people do things, you must call up elders, you must call authority, you must call people to prove that actually this is your custom, because the judge don't know your custom. Do you understand? But I don't want you to go there, because it's something you are going to encounter in first semester in legal system. It should be the headache of those offering legal system. If you are offering it, we shall still come in under that. We treat it as it is. But what you ought to know is that customary law are valid law, provided that it meets or it met three requirements. Number one is repugnancy text doctrine, meaning that it must not be something that is absurd. You cannot say that you don't want to, that you want to, maybe if somebody give birth to twins, you want to kill the twins because it's your custom. It's repugnant to natural justice. Then the next thing again, we have what? Compatibility test. Compatibility test means that if customary law is to be applicable, it must not be what? Incompatible with law. Remember section 113, that any law that is inconsistent to the constitution is null and void. That is what we are saying. If your custom must be applied, it must be in conformity with what? The constitution. Then we have the public policy test. Public policy test, there is one tradition in my place whereby a girl can just be, when, if a man didn't give birth to male child and it's the only girl she has, the family have, the family can keep the girl, and the girl will be moving around prostituting or begging men to sleep with her so that she can bring back more people to that family. So she can sleep with this party A and get a child. She can sleep with party B just to make sure that the family doesn't, go into extinction, so to say. The girl will just be prostitute. That one is official backed up prostitution. But that thing is against public policy in the sense that the law does not encourage such, idiosyncrasy out of a woman just going around and doing. That one is a typical example of public policy, meaning that it must not be something that is against public policy. Public policy, there are some certain things, not only that it is immoral, but it is against what the society stands for. So whenever your custom of your village people are against what the society stands for in this kind of modern world, it will not be applicable. But customary law, provided it meet up these three requirements, they applies. Whether they are written down or not, it doesn't matter, provided you can prove it. He who has that must provide. Then we have the Islamic law. Islamic law, just like customary law, are still applicable in courts. They are still applicable. They are still applicable. And the beautiful thing about Islamic law is that their own is more of written down. So you have the Quran as the chief custodian of Muslim law. So Quran prescribe what ought to be done and what not to be done in many cases. And their own is still applicable. But in our own customary law, it is not written down anywhere. Even now, effort is made to codify customary law. But whenever customary law is fully codified, it lacks that kind of idea of being customary law anyway. Because it is a story that is told from generation to generation. But Islamic law does have that kind of, it's something that originates from Prophet Allah and Muhammad. Prophet Muhammad, and then up to Allah, that is the chief custodian of their religion. So that is it about Islamic law. Then I want you to know the types of Islamic law. Now, because of the importance of Muslim law, I want us to consider it. Like I said, I'm going to tell you how to answer questions coming from this section. But when you look at Muslim law or Islamic law, we have just like under this one, we have the constitution, we have the penal code, we have the criminal code, and then this thing here, and that thing that is called legislation. So also under here, remember we didn't talk about this one because this one is not stable, it's not written down anyway. The types can be your own custom, and in fact, every custom varies. So this one cannot be streamlined anyway, but this one is very, very stable. So we have the Quran, and the Quran is the rules of Muslim. Quran is their religion, the guideline, just like the Bible and every other thing. Quran is the chief. Quran is their first heir to Ringo, the fountain of all Muslim laws. Then we have the Sunnah. Sunnah basically refers to the actions, deeds of Prophet Muhammad. So Prophet Muhammad during his life led exemplary life to the Muslims. So because those his exemplary lives, those his actions and inactions are codified as forming part of the corpus juris of Islamic law. Then we have the Ijma. Ijma is the consensus of Muslim jurists. So this one is basically the consensus. And remember, this one is their constitution, the first heir to Ringo. This one is the actions. Then this one is what? The decision or the consensus of. You can see this one referring to the kind of case law, but it's not that way. There are times there is not everything that is written down in Quran. So when they want to interpret it, whatever they form as consensus can be referred as ijma. That their consensus is also part of it, that you can cite it and say that this thing abounds or this thing binds. Then we have the qiyas. So qiyas now is the analogical inference. Remember, they're just like case laws. Whenever the judges are deciding matter, they make an analogy. They used to infer. A good example is that Quran contains the provisions for the punishment of theft. But if you go to Quran, there is no provision for the punishment of burglary. Remember, it is law that differentiated theft from burglary, and Quran could not have contemplated of that. So if somebody is charged with burglary, the court using this, or the Muslim court using this medium of qiyas, they can possibly give an analogy that since theft is punishment of theft is amputation of the person's hand, it can also apply in burglary. That is what we mean by analogical inference. That is called drawing inference. Now, we turn our attention to this side, which is purely primary sources, secondary sources. What is it all about? What is basically this part talking about? That is what we are going to consider on our part 2 video. And what we have done here is to put up sources of law. But this one is very important. If I'm in my school, this is where the question is going to come from. Because this is what will make you to truly test you whether you have understood this part very well. Without this, your knowledge of here, everything you know here will be useless. But on the part 2 of our video, we shall continue this side. I don't want this video to be so long for some people who hate long videos. We shall continue on that side. But then before you go, I have something to tell you. If you are in my school, I will be coming out for the position of faculty president for my school. And if you are watching this video, you owe me a lot by voting for me, because the vision I have for my faculty and the entire Law Students Association of Nigeria is a big one. Support me and you see how this platform is going to change for the greater good of laws and I. If you have not liked the video, like and subscribe. And if you want to watch that video I talk about common law and equity and all those things, you can click the link above. If you want to watch part 2, you can also click the link above. Whichever way, I shall see you there and we'll continue making impacts. Thanks for watching and like the video.